203. One one nine four. One one nine five. 1196. 1197. 1198. 1199. 1200. 1201. 1202. 1203. 1203. 1204. 1205. 1206. 1207. 1208. Senator Ali Wakili, Bauchi South.
Your Excellency, sir, my name is Senator Manam Ali Wakili. I represent Bauchi South. I do hereby move that votes of and proceedings of Tuesday, 28th February 2017 be approved. I so move.
Senator Peter Nwabuchi, Delta North.
Mr. President, I rise to second the motion for the adoption of the vote of proceedings of Tuesday, 28th February 2007. I so second.
Distinguished colleagues, those in favor that the votes and proceedings of Tuesday, 28th February 2017 hereby approved, say aye. Those against, say nay. The ayes have it. Votes and proceedings of 28th votes and proceedings of Tuesday, 28th February 2017 hereby approved. Announcements. Letter from Senator Eyina Baribe. Your Excellency, invitation to the 4th edition of Made in Aba Fair in Abuja. It is my pleasure to invite my distinguished colleagues to the 4th Made in Aba Trade Fair in Abuja. The objective of the fair is to promote Made in Aba and Nigeria products to domestic and international consumers and encourage our citizens to patronize locally made goods. The fair is my zonal intervention project of 2016 in partnership with Small and Medium Enterprise Agency in Nigeria, Sweden. Venue, Arts and Craft Village, opposite Sheraton Hotel, beside Yaradua Center, Silverbird Cinema, Abuja. Date, 6th of March, Monday to Friday, the 10th of March. Opening date time, 11 a.m. As you come to support the fair, please be assured of my highest regards. Senator Eyina Baribe. Letter from Senator Dr. David A.B. Mark, GCON. Your Excellency, my dear brother, appreciation. I write to express my profound appreciation to you and my distinguished colleagues for honoring my invitation to the launching of I Will Give, IWG, a project of Shestrad International at a very short notice. The project, among other things, is designed to restore human dignity, sustain livelihood, and save lives, especially among the underprivileged and vulnerable in the society. I am deeply touched that you are able to send a high-powered representation led by the Senate Leader, Senator David Ahmed Lawan, CON, Minority Whip, Senator Philip Aduda, MFR, and Senator Gesham Bassi to attend the event that ordinarily crashed into your already scheduled program. Please extend my deep appreciation to my colleagues. Majority of them called on phone while others sent text messages to express their solidarity and goodwill towards the success of the event. Thank you. Yours sincerely, Senator David A.B. Mark, GCON, Chair, Global Ambassadors Council. Letter from Senator George Akume. Your Excellency, notification and invitation to attend the coronation of Totiv V, His Royal Majesty, Professor James I.O. Asheteshe. I write to notify His Excellency, the President of the Senate, and our distinguished colleagues that His Royal Majesty, the Totiv, Professor James I.O. Asheteshe will formally be coronated and presented with staff of office by the Executive Governor of Benue State, His Excellency Simon Otom, on the 4th of March 2017. This historic event will take place in the Tiv ancestral town of Boko by 10 a.m. We are by this notification formally inviting His Excellency, the President of the Senate, and our distinguished colleagues to find time from the usually crowded schedule to honor the Tiv nation and the entire people of Benue with their distinguished presence. Reception follows in the country home of Senator Akume. Signed, Senator George Akume and Senator Barnabas Gemade. Let me announce the delegation who will be going to South Africa to meet with the parliamentarians over there. We're led by the Deputy Senate President, the Senate Leader, Chief Whip, Senator Shehu Sani, Senator Shaba Lafiaji, Senator Magnus Abe, and Senator Stella Odua. Let me also join our colleagues in congratulating Senator Aliyu Magatakada Wamako, whose birthday is today, the 1st of March, and also Senator Ina Baribe as well. We wish you many, many years of good health and service to the country. I wish to acknowledge the presence of the staff and students of the Regent Secondary School, Mabushi District, Abuja. Staff and students of Cedar International Secondary School, Kubwa, Abuja, who are in a gallery to observe Senate proceedings. I wish them all a fruitful observation of the Senate proceedings. You may sit down. Any petitions? Yes. Deputy Chief Whip.
Mr. President, distinguished colleagues, my name is Senator Francis Ali Mikena, representing the good people of Edo North. Mr. President, I have a petition for one of my constituents, Christian Iyafere, whose appointment was wrongly dismissed by the University of Benin. He has a petition here, and the matter is not before any law court.
Yeah, come and lay the petition. Petitions refer to ethics and privileges. Report back in 2 weeks. Yes, Senator Mao Wabon.
Mr. President, distinguished senators, my name is Senator Mao Arugo Wabunwa, represent the people of Abia North. Mr. President, I have two petitions from my constituents. One is from Chief Joseph Ogo, whose land was confiscated and reallocated to River Plate properties by AMAC. And he's asking the Senate to look into this petition and ensure that justice is done. And this petition is not encumbered in any way, legally, politically, spiritually, and otherwise. Then I have the next one, the next motion, the next petition is from another constituent of mine, Chidi Waha, against the Nigerian police, who is alleging wrongful detention and dismissal from the Nigerian police without trial. And he's requesting that this Senate should look into this case and ensure that justice is done. Mr. President, by your permission and direction of the Senate, I want to lay this.
Yeah, come and lay the petition. Petitions refer to ethics and privileges. Report back in 2 weeks. Yeah, Senator Aidoku.
Thank you, Mr. President, my distinguished colleagues. My name is Senator Atai Aidoku Ali. I represent Kogi East. Mr. President, I have a petition from one of my... Mr. President, I have a petition from my constituent, Mr. Samuel Odiba, who is unlawfully dismissed from the employment of NDLEA
And Mr. President, he's asking the Senate to look into this issue. With your permission, may I lay this?
Yes, come and lay the petition. Petition is referred to ethics and privileges for back in 2 weeks. Senator Wakil.
Your Excellency, sir, my name is Senator Madam Ali Wakili, MNI. I represent Bauchi South. Sir, I have a petition from Academic Staff Union of Polytechnics, Bauchi Polytechnic Branch. Like, you know, sir, that most of the academic staff unions of the universities and the polytechnics have running battle against some of their management over some issues of payments of some of their allowances and stipends. That was the Federal Polytechnic Bauchi. They have served a warning strike, which they have withdrawn. If you don't intervene by tomorrow, sir, the Polytechnic will go on indefinite strike that will affect most of our students. I want you to use the opportunity of this petition and
come and lay the petition. Petition is referred to ethics and privileges. Report back in 2 weeks. Petition Senator Dimlai.
Mr. President, my very respected colleagues, I have a petition of unlawful, unconstitutional, and inhuman conditions under which my constituent was detained by the Nigerian Navy and the State Security Service. Mr. President, there is no legal remedy being sorted.
You come and lay the petition. Petition is referred to ethics and privileges. Report back in 2 weeks. Leader of the Senate.
Mr. President, distinguished colleagues, the first business of the day is the presentation of the Conference Committee report on the agricultural credit and...
Leader, just a second. Point of order, Senator Abaybe.
Thank you, Mr. President. I'm sorry, my leader. I was a little distracted, so I will have raised the point of order just before you. My apologies, my leader. Mr. President, I'm coming under Order 43, and if you permit me, I will read.
Go ahead.
By the indulgence of the Senate and the leave of the President of the Senate, a senator may make a personal explanation, though there be no question before the Senate. But no controversial matter may be brought forward, nor may debate arise upon the explanation. The terms of the proposed statement shall be submitted in detail to the President of the Senate when his leave to make it is sought. Mr. President, I came to you this morning and I told you I was going to raise this personal explanation just to assure the people of Abia State, the people of Ondo State, and the people of Imo State. Mr. President, on Tuesday, the 11th of October, 2016, this chamber confirmed members of the present commission of the NDDC, Niger Delta Development Commission. By the NDDC Act 2000, Section 2B states that the representation on the commission shall be one person who shall be an indigene of an oil-producing area to represent each of the following member states, of which the 3 states aforementioned were part of. The nominees that came at that time were not in conformity with this portion of the Act, and therefore, in confirming the nominees, including the chairman, I know that this chamber also asked the president and commander-in-chief to forward to this chamber another set of nominees for these 3 states. Since 2016 October till now, it's about 5 months. And we want to please use this opportunity to let Mr. President, yourself, and the party called APC, that there are members of APC in Abia, members of APC in Imo, members of APC in Ondo, and therefore we don't think that manpower is lacking in making sure that this law is fulfilled. All the oil-producing areas have enough manpower to fulfill this portion of the Act, and therefore we plead earnestly as the senator representing the oil-producing area of Abia State, and I have the mandate of the senator representing the oil-producing areas in Imo, Senator Hope Uzodinma, an oil-producing area in Ondo State, that something should be done and done as urgently as possible. I so make this explanation so that my people will know that I'm fighting for them.
Thank you, Senator Abari. I'm sure your people always know you are fighting for them. When you said since, I thought you were going to say since 2015. I didn't know your since is just last year, October. Anyway, your fighting explanation is noted. Leader of the Senate.
Mr. President, thank you very much for being very generous with your ruling on the point of order raised by my friend and colleague, because it was a very controversial matter. The APC cannot be so called. The APC is the party in government today, and will continue to be. Mr. President, Mr. President, distinguished colleagues, the first business of the day is the presentation of the Conference Committee report on the Agricultural Credit and Guarantee Scheme Amendment Bill 2017. Mr. President, you may wish to invite Senator Abdullah Adamu, Chairman of the committee, to move the motion for the Senate to receive the report. Who is present?
Senator Theodore Oji.
Your Excellency, Senate President, my distinguished colleagues, my name is T.A. Oji. I am the Deputy Chairman of the Agri Committee. We're having some issues on this paper. I want to resolve it. It's one of those that the President is withholding asset. So we want to sort out the issue and meet with members of the House before we come and represent.
All right, Leader, we will step it down here.
Mr. President, I move that we step down the presentation of this report till another legislative day.
Mr. President, distinguished colleagues, I rise to support the motion that we step down this report to another legislative day. I so second.
Distinguished colleagues, those in favor that we step down this item to another legislative day, say aye. Those against say nay. The ayes have it. Leader of the Senate.
Mr. President, distinguished colleagues, The first order of the day is a motion standing in the name of Senator Ike Ikwaramadu on the enhancement of the powers of the Parliament of the Economic Community of West African States, ECOWAS Parliament. Mr. President, you may wish to invite Senator Ike Ikwaramadu to move the motion.
Deputy Senate President.
Thank you, our President, very distinguished colleagues. It is my joy and pleasure to move this particular motion on the enhancement of the powers of the Parliament of the Economic Community of West African States, ECOWAS Parliament. Very distinguished colleagues, as you are aware, the founding fathers of ECOWAS, spearheaded by our own former head of state, General Yakubu Gowon, retired, GCFR, established the ECOWAS via the Lagos Treaty in 1975, which was also reviewed in 1993, all in the effort to foster economic and political cooperation of the peoples of West Africa. You will recall that the ECOWAS Parliament was established by Article 13 of the 1993 revised Treaty of ECOWAS as representatives of the peoples of West Africa, while the composition, modalities for election of community parliamentarians, the functions, powers, and organization of the community parliaments were spelled out under ECOWAS Protocol A/P2/8/94 of 1994, which came into force on March 14th, year 2000. Further recall that the ECOWAS Parliament has existed as a mere advisory body since its establishment in 2000, although ECOWAS decision A/December 6, 01/2006 defined and strengthened the modalities for interaction between the community parliament and other community institutions. You also note that the new Article 13 of ECOWAS Supplementary Protocol of 2006 provides, I quote, that the powers of ECOWAS Parliament shall be progressively enhanced from advisory to co-decision making and subsequently to law-making role in areas to be defined by the authority. We note that although efforts by the preceding legislature of the community parliaments to have the powers of the parliament enhanced in line with the new Article 13 were unsuccessful, the third legislature of the parliament, under my leadership, championed a robust advocacy for the actualization of this project, including coming up with a draft supplementary act on the enhancement of powers of the community parliament to bring the institution to the international best standards as other regional parliaments like the East African Legislative Assembly and the European Union, among others. Further note that although the supplementary act was adopted by the 46th ordinary session of the ECOWAS Authority of Heads of States and Government in Abuja in December 2014, the 47th ordinary session of that authority failed to sign to bring it into force in Accra in May 2015, before the expiration of the third legislature, which I headed as the speaker. Aware that the fourth legislature of the community parliament had continued with the relentless effort towards realizing the enhancement of the powers of the parliament, we receive with joy and immense pleasure the eventual endorsement of the ECOWAS Supplementary Act A/SA/1/12/16 relating to the enhancement of the powers of the ECOWAS Parliament by the 50th Ordinary Session of the Authority of Heads of States and Government in Abuja in December 2016. Conscious of the fact that this Supplementary Act now bestows on the Community Parliament enhanced competencies, namely, 1, involvement in enactment of all community acts related to ECOWAS economic and monetary integration policies or treaty. B, involvement in adoption of the community budget, which before then they didn't have. C, exercise of parliamentary oversight functions over the activities of program implementing bodies of the community and to adopt appropriate resolutions in so doing. D, consideration of any matter concerning the community, in particular issues related to human rights and fundamental freedoms, and make recommendations to the institutions and organs of the community in this regard, and constitution of committees of inquiry and mediation on such matters. E, consultation of the parliament on any issue concerning the community, except on matters relating to internal agreements affecting community institutions, membership, sanctions, suspension or exclusion of member states by community, creation of institutions and community defense, peace and security policies. and F, proposition with the ECOWAS Council of Ministers and the ECOWAS Commission, model and uniform laws for the community. We note again with joy that Article 18 of the Supplementary Act provides for the eventual election of community parliamentarians by direct adult suffrage. Accordingly, we seek that this Senate do resolve to commend the ECOWAS Authority of Heads of States and Government for finally enhancing the powers of the community parliament in line with the international best practices. 2, commend this as a major achievement towards the democratization of the governance of the sub-regional body and promotion of the fine principles of separation of powers and checks and balances. 3, congratulate the community parliament on this milestone. 4, commend all the organs of ECOWAS and individuals who championed the cause, worked tirelessly, and made personal sacrifices towards the actualization of a true parliament for the peoples of West Africa. 5, commend members of the international community, especially the various international organizations and development partners which supported and committed their resources towards the achievement of this feat. And finally, but very importantly, call for the amendment of the Electoral Act of the Federal Republic of Nigeria to empower the Independent National Electoral Commission, INEC, to conduct election to fill the nation's 35 seats at the community parliament. As so moved.
Thank you very much, Mr. President and my distinguished colleagues. This is a very straightforward motion. Straightforward in the sense that the necessary intent is to bring the ECOWAS Parliament in conformity with other international parliaments like the African Union and European Union, And what is the purpose? Is to enhance the checks and balances that exist between parliament and the executive of these member countries. And this will further enhance and give authority to the parliament to perform its function without let or hindrance. And I am of the opinion that any attempt to elevate what has hitherto been below what is obtainable around the world should be supported by this parliament. I'm therefore of the opinion that it's so straightforward that we do not need to waste so much time on this matter other than to just take the two intents of the motion and to accept the fact that it is reasonably necessary at this time of our history as a parliament. I therefore urge that all my colleagues support this straight motion without any debate. Thank you. And conclusively, I therefore ably second the motion as ably moved by the Deputy Senate President, the Eco Howard.
Distinguished colleagues, I think it's a pretty straightforward motion. Let's go straight to the prayers. Prayer 1, commend the ECOWAS Authority of the Heads of States and Government for finally enhancing the powers of the community parliament in line with international best practices. Those in favor of prayer 1 say aye. Those against say nay. The ayes have it. Prayer 2, commend this as a major achievement towards the democratization of the governance of the sub-regional body and promotion of the fine principles of separation of powers and checks and balances. Those in favor of prayer 2 say aye. Those against say nay. The ayes have it. Congratulate the community parliament on this milestone. Those in favor of prayer 3 say aye. Those against say nay. The ayes have it. Prayer 4, commend all the organs of the ECOWAS and individuals who championed the cause, worked tirelessly and made personal sacrifices towards the actualization of a true parliament for the people of West Africa. Those in favor of prayer 4 say aye. Those against say nay. The ayes have it. Prayer 5, commend members of the international community, especially the various international organizations and development partners which supported and committed their resources towards the achievement of this feat. Those in favor of prayer 5 say aye. Those against say nay. The ayes have it. And prayer 6, call for the amendment of the Electoral Act of the Federal Republic of Nigeria to empower INEC to conduct election to fill the nation's 35 seats at the community parliament. Those in favor of prayer 6 say aye. Those against say nay. The ayes have it. Additional prayer. Yes, Philip Adula.
Thank you, Mr. President, distinguished colleagues. We thank the ECOWAS for giving us for the 35 seats. But however, Mr. President, there are 36 states and including FCT, making it 37. So if we were to go by state, one for each state, there will be 35 states and one state will be missing, and then one which is supposed to be federal capital will be out of it. So my additional prayer would be that ask them or urge them to add 2 more seats to make it 37 seats. That's my additional prayers. Thank you, Mr. President.
Anybody seconding the prayer? Distinguished colleagues, let me thank the Deputy Senate President for this motion. Let me also join others to say this is a major achievement in our sub-region. The endorsement by the heads of states and government of the ECOWAS on the Supplementary Act truly enhances the powers of the ECOWAS Parliament, and is indeed historic and very, very commendable. I want to thank all those that worked towards it. I thank our own Deputy Senate President and the leadership of the Parliament. This is something we should all be proud of. It's a victory not only for the legislative democracy, but I think the coming together of the ECOWAS body into a more people-orientated and focused assembly. And we charge the regional body to take advantage of this to ensure that we continue to work for the actualization of regional integration. Leader of the Senate.
Mr. President, very distinguished colleagues, the second order of the day is a motion standing in the name of Senator Dino Melaye on the discrepancies in subsidy payment and non-remittance of funds by the NNPC to the Federation account. Mr. President, you may wish to invite Senator Dino Melaye to move his motion.
Senator Dino Melaye.
Mr. President, my very patriotic colleagues, my name is Dino Melaye, Kogi West. Mr. President, I yet again rise in pain to move this motion once again in the course of our nation's history. Mr. President, very, very patriotic colleagues, the Senate, aware that majority of Nigerians overwhelmingly agree to fight corruption, and this informed the present administration's resolve to tackle the widespread corruption in all its ramifications, inclusive of the petroleum industry. My respected colleagues, the Senate notes with dismay that despite the crackdown on corruption by the present government led by President Muhammadu Buhari, there has been continuous violation by the Nigerian National Petroleum Corporation, NNPC, as regards non-remittance of proceeds from the sale of refined products into the Federation account. This practice is similar to the problems that sparked the national outrage against the last administration. Mr. President, the Senate is aware that though independent marketers account for 49% of imported petroleum products, while the Nigerian National Petroleum Corporation, NNPC, account for 51% of imported products, but this does not justify the huge amount it has been paid as subsidy in the last 10 years. My respected colleagues, the Senate is concerned that from the records derived from NNPC, 5 to 10 cargoes of imported crude arrive the country monthly, while about 5 cargoes are refined locally and each cargo contains 5.8 million liters of refined crude products. Mr. President, my very respected colleagues, the Nigerian Senate is worried that the excess products which cannot be dispensed that goes into different tank farms owned by private individuals are not properly accounted for, as they are illegally sold off by the owners of these tank farms in manner that is opaque and usually designed to rip off the public and enrich a few persons stupendiously at the expense of the masses of this country. The Senate is disturbed that since this administration clamped down on subsidy payments, NNPC has solely been responsible for retail with companies like Bovas and Rhino Oil paying 20 to 25 naira per liter for the sale of these products, which amount to over 2 billion naira monthly. Mr. President, my respected colleagues, the Senate further disturbed that these monies are not accounted for, and that might be the reason why we now see petrodollars buried in caskets and uncompleted buildings in remote villages in some parts of the country. Mr. President, the Senate accordingly resolved to mandate the Committee on Petroleum Downstream to exhaustively review and investigate the NNPC over its accounts relating to fuel subsidy and the abuse of product marketing and distribution between 2006 and 2016. Mr. President, the Senate is the hope of the Nigerian people. This morning again, there is a clarion call by the Nigerian people on distinguished Senator Dr. Bukola Saraki and his colleagues to help again in the fight against corruption. Are we going to accede to this call? As I speak to you, Mr. President, some of the monies we are mentioning here could be part of what was found in Sabon Tesha in southern Kaduna recently. Mr. President, the Nigerian Senate must, as a matter of urgent national importance, curb these corruption, block wastages and leakages in the system. We cannot get out of recession if the fight against corruption is not fought headlong. We will continue to expose corruption here, but it is also mandatory of the Nigerian Senate to make sure that those found wanting are not only prosecuted, but they face the full wrath of the law. Mr. President, if we don't kill corruption, corruption will kill us. Mr. President, I appeal to us, because I am again tempted to cry before this chamber. I appeal to my colleagues that this cankerworm must be fought to stand still this time. This investigation must be the last and permanent solution to the corruption in the oil industry. This must completely be separated from what happened in the subsidy investigation in 2011. I appeal to us that these leakages must be blocked. Every Nigerian found wanting must be prosecuted. We must salvage our economy. We must plan for the future of generation yet unborn, and the time to do it, Mr. President, is now. Thank you very much. I so move.
Senator Albert Bassi, Akwa Ibom, noticed.
Thank you, Mr. President. My distinguished and respected colleagues, Mr. President, I remain Senator Albert Bassi, representing the good people of Akwa Ibom Northeast. Mr. President, I rise to second this motion and to state very clearly, Mr. President, that there are two challenges
that is facing the Nigerian economy. And that if we are committed and we are determined to recover our economy from recession, then two things must be taken into consideration. The attention we pay to issue of petrol product price deregulation, as well as our interest rates. The interest rate, I don't know the miracle that the CBN is doing, but I think we are beginning to see progress in that regard. But Mr. President, let me state clearly that the content of this motion is extremely very grievous. I'm equally aware, Mr. President, that as we speak, NNPC is indebted on first subsidy to independent petroleum marketers as well as the major oil marketers to the tune of about $1.4 billion. And most of the challenges we have in our financial institutions today is as a result of these outstanding obligations of product importers on the banks. There is no bank in this country today that can be said to be very healthy because of the outstanding liabilities of petroleum products marketers. And as we speak, Mr. President, it should also be placed on record that the government of the Federal Republic of Nigeria had actually issued a sovereign guarantee to these product marketers that any debt owed the marketers as a result of the importation of petroleum products will be paid by government. So this $1.5 billion amounting to over 600 and something billion naira is a liability to government. So I support this motion in totality, Mr. President, and this is the reason why, as we speak today, NNPC is the sole importer of petroleum products, and these products are being imported into the country at a loss. It is on record that in the last 3 to 4 months, we have incurred over a loss of about 120 billion naira on imported petroleum products. So I support this investigation, Mr. President, and I urge all my colleagues to support this investigation so that we will display that courage that will sustain and help this country. We must protect the interests of all Nigerians for the good of all. Thank you, Mr. President.
Senator Sekibo.
Mr. President, and my distinguished colleagues, I am Senator George Thompson Sekibo, CON. I represent the Rivers East Central District. Mr. President, when motions like this comes up, it grieves our heart. Why do I say so? Nigeria ought to be one of the richest countries in the world. As one of the greatest producers of oil and hydrocarbon and gas. But today, it is noted all over the world that we are in recession. And after recession, depression comes in. After depression, what comes up? There may not be a country. Now, years ago, Nigeria had oil boom. Virtually in every 5-10 years, God raised an opportunity for the country to be richer. But because of leadership, people were entrusted with the revenue of this country and are not spending it prudently, harnessing it prudently. That is why we have gone down the drain to this recession. Mr. President, I want to refer us to the Constitution. Section 15, Section 15:5. It says this: the state shall abolish all corrupt practices and abuse of power. Recently, they dug in somebody's pit and got billions of naira. That was a man that was also in charge of the same industry. Today, similar events are coming up. If we don't work hard, investigate properly, and call to book whoever is guilty, then this trend will be continuing. Mr. President, if you look at Section 16 of our Constitution, subsection 2B and C, that the material resources of this nation are harnessed and distributed as best as possible to serve the common man. When few individuals are making 2 billion in a month, 24 billion in a year, and then the others are lavishing in poverty, can that continue as a good country? Therefore, we call on you today to be sure that the investigation that will be carried out today on this matter be prudently be done to the last, and if any person is found guilty, such persons must face the wrath of the law. I take it to section 16(2)(c), that the economic system is not operated in such a manner as to permit the concentration of wealth or the means of production and exchange in the hands of a few individuals or of a group of people. Mr. President, that's where the problem comes. When one man is harnessing $9 billion, when few people are getting $1 billion in every week, how can we come out of this recession? For us to come out of this recession is to join the president wholeheartedly and fight this corruption battle sincerely. I so support. Thank you very much.
Distinguished colleagues, I think this is pretty straightforward motion. So we'll go to the prayer. Prayers is to mandate the Committee on Petroleum Downstream to exactly review and investigate the NNPC overseas accounts relating to the fuel subsidy and the abuse of product marketing and distribution between 2006 and 2016. Those in favor of prayers say aye. Those against say nay. The ayes have it. Any additional prayer? No. Distinguished colleagues, let me thank Senator Dino Milaya and all those that contributed to this motion. As said by those that contributed, this motion borders on the issue of corruption in the most important sector of our economy, which is petroleum sector. We must get to the bottom of these acts, which I would like to believe that they're not institutional, or where individuals just believe that they can do what they would like to do and are not accountable to anybody. I want the committee to investigate this thoroughly, prudently, and I want all the members of the committee to ensure that a thorough job is done and to ensure that we get a report to tell us exactly what is going on. We cannot continue in a country where people continue to add hardship to our people just because of their corrupt practices. So the chairman of the committee and members, please ensure you do a thorough job and bring a report to us as soon as possible to get to the bottom of this situation. Thank you. Leader of the Senate.
Mr. President, very distinguished colleagues, the third order of the day is a motion standing in the name of Senator Philip Aduda and Senator Dino Melaye on the continued implementation of the Federal Capital Territory Statutory Appropriation Act 2016 and for other related matters pursuant to Section 122 and 299 of the 1999 Constitution of the Federal Republic of Nigeria as amended. Mr. President, you may wish to invite Senator Philip Aduda to move the motion.
Senator Aduda.
Thank you, Mr. President. Thank you very much, distinguished colleagues. This motion is co-sponsored by me and distinguished Senator Dino Melaye, the chairman of the Committee on the Federal Capital Territory. It's a motion for the continued implementation of the Federal Capital Territory Statutory Appropriation Act 2016 and for other related matters pursuant to Section 122 and 299 of the 1999 Constitution of the Federal Republic of Nigeria as amended. The Senate notes that the FCT Appropriation Statutory Act 2016 was passed on 20th July 2016. Notes further that the bill was assented to by the President Commander-in-Chief of the Federal Republic of Nigeria in August 2016. Further concerned that the FCT Appropriation Act operated for only 5 months before it elapsed, that is 31st December 2016, as captured in the 2016 FCT Statutory Appropriation Act. Observe that the FCT has been indicted with complaints of non-payment for infrastructural development, satellite town developments, and city cleaning services due to budgetary constraints. Also observed that the city has slided into environmental embarrassment, especially the Whooper sewage treatment plant. Note that Section 122 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, provides as follows. If the appropriation bill in respect of any financial year has not been passed into law by the beginning of the financial year, the governor may authorize the withdrawal of monies from the Consolidated Revenue Fund of the state for the purpose.
Senator Philip, can you stop for a second? Distinguished, we can't definitely conduct the plenary session like this. Let us respect the chamber that we are and also respect our colleagues. Thank you.
Thank you, Mr. President. Consolidated Revenue Fund of the state for the purpose of meeting expenditure necessary to carry on the services of the government for a period not exceeding 3 months or until the coming into operation of the law, whichever the earlier, provided that the withdrawal in respect of any such period shall not exceed the amount authorized to be withdrawn from the Consolidated Revenue Fund of the state under provision of the appropriation law passed by the House of Assembly for the corresponding period in the immediately preceding financial year, being amount proportionate to the total amount so authorized for the immediately preceding financial year. Note further that Section 299A of the 1999 Constitution of the Federal Republic of Nigeria, as amended, provides as follows. The provision of this constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation, and accordingly, all the legislative powers, the executive powers, and judicial powers vested in the House of Assembly, the governor of a state, and in the courts of a state shall respectively vest in the National Assembly, the President of the Federation, and in the courts which by virtue of the foregoing provisions are courts established for the Federal Capital Territory, Abuja. Accordingly resolves to draw the attention of the Federal Capital Territory Administration to the provision of Section 122 and 299 of the 1999 Constitution of the Federal Republic of Nigeria as amended, authorizing them to continue to spend money based on the previous Appropriation Act up to 6 months from the 31st day of December 2016 or until a new budget is passed into law for the FCT. I so move, Mr. President, distinguished colleagues. Thank you very much.
Yes, Senator Dinmilai.
Mr. President, my colleagues, Dino Milai, Kogi West. Mr. President, the motion moved by distinguished Senator Philip Tanimu Aduda is a very straightforward motion. The Federal Capital Territory is the seat of power, and as I speak to you, they are operating in pain because they cannot spend money because the Appropriation Act for the FCT was passed only in August or signed into law in August last year. So there's an impediment to the operations of the FCT, and they cannot spend since the 31st of December elapsed. And in consonance with the provisions of the Constitution as provided in Section 229 of the Constitution of the 1999 Constitution, we are seeking for just the resolution of this Senate to extend the financial year of the FCT so that all the operation of this city will not cease. I want to please call on my colleague in the interests of Nigeria and the Federal Capital City to please pass this resolution so that the monies in the coffers of the FCT will be properly spent for the benefit of the inhabitants of this city. I so second.
Senator John Eno.
Mr. President, my name is John Owaneno, Cross River Central. Mr. President, going by the resolution that is sought, it is to enable the FCT administration to spend money as guaranteed by the Constitution in a new year in which there's not a budget yet. And I think these are already constitutional provisions. And I think that, it's just like the national budget. That we don't have a national budget, even if we didn't extend the budget implementation year, that the government has the power, constitutionally to spend, but in talking about this now, it's either, okay, we have the FCT budget that was passed. Now, if at the passage of that budget, it wasn't indicated like we indicated in the national budget that it should be 12 calendar months. If we didn't do so, I think what it would require really is to amend that law, that FCT budget law, for an extension or to allow them to spend for 12 calendar months. If we're not doing so, then I think that it's already implied that if the FCT doesn't have a budget yet for 2017, that they will continue to spend money until they have a new budget. I think that's what it is. So I really don't think that it would require really having to do a resolution of the Senate for them to do what the Constitution says they should do.
Deputy Senate President.
Yes, sir. Thank you, Mr. President, distinguished colleagues. As stated by the mover of the motion, the budget is already expired, so we can't extend it. So the only thing we can do is what he's requesting, to call the attention of the FCT administration to the provisions of the Constitution that enables them to expend money beyond the period which the act provided, so long as it does not exceed more than 6 months into the preceding years. And that's the only thing we can do, but we cannot amend the act to extend because it already expired by the 31st day of December 2016. So we can't be able to extend something that's already expired. So what he did is the correct thing in law.
Distinguished colleagues, if they're able to go to the prayer before us then. Draw the attention of the Federal Capital Territory Administration to the provisions of Section 122 and 299 of the 1999 Constitution of the Federal Republic of Nigeria as amended, authorizing them to continue to spend money based on the previous Appropriation Act up to 6 months from the 31st December 2016 or until a new budget is passed into law for FCT. Those in favor of the prayer say aye. Aye. Those against say nay. The ayes have it. Distinguished colleagues, I thank you, Senator Philip Aduda. Both yourself, Philip Aduda, and also Senator Dino Malaya, you have the responsibility, because I think really what we're saying here is that is to clear the ambiguity that if the FCT administration believes they needed the motion. But I think the whole point of it is to ensure that they do utilize the budget for the interest of the people in the FCT. So it will be your responsibility, and also call the minister and the executive in charge to know that they should ensure that they do implement the budget of 2016 and for the interest, and no excuses should be accepted or taken now that we've done this. Thank you. Leader of the Senate.
Mr. President, very distinguished colleagues, the fourth order of the day is the screening of Honorable Justice Walter Onagian for appointment as Chief Justice of Nigeria in accordance with Section 231, subsection 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Mr. President, distinguished senators, in order to carry out this exercise in conformity with our Standing Order 17, floor privileges, I will move 2 motions. First, I move that the Senate do resolve into the Committee of the Hall to conduct the confirmation hearings.
Mr. President, my distinguished colleagues, I rise to second the motion moved by the leader that we do resolve into a committee of the whole to continue this exercise. I so second.
Distinguished colleagues, those in favor of the motion that we resolve into committee of the whole, say aye. Those against say nay. The ayes have it. Leader of the Senate.
Yeah. Mr. President, in the chair, very distinguished colleagues. Secondly, I move that the Senate do admit the Cross River State Governor, Special Advisor to President on National Assembly matters, and the nominee and other judicial officers into the Senate chamber.
Mr. President, my distinguished colleagues, I rise to second the motion moved by the leader that the Senate do admit the nominee and other strangers to enter the chambers. I so second.
Distinguished colleagues, those in favor of this motion say aye. Those against say nay. The ayes have it. Sergeant of Arms, if you can usher in the advisor and all the governor and also members of the Supreme Court judges who are accompanying the nominee.
Order, please. Order, please. Can we have some quiet in the chamber, please? Order, please. Distinguished colleagues. Order, please. Senator Rogide, please take your seat.
Don't call me, I'm going to give.
Senator Dua, please take your seat. Senator Akpan, please take your seat. Senator Utaze, please take your seat. Senator Ataridoko, please take your seat. Senator Ataridoko, please take your seat. Senator Ataridoko, please take your seat. Senator Adokwe, please take your seat. Senator Doko, please, you are delaying Senate business. Please take your seat.
Don't call my name. Don't call my name.
Please take your seats, distinguished colleagues. Senator Emmanuel Pokra, please take your seat. Senator Malafa, please take your seat. Senator Bukar Abba Ibrahim. No gubernatorial immunity in this chamber. Distinguished Senate President, we are set.
Thank you, Chief Whip. Distinguished colleagues, we are with us this morning the Acting Chief Justice of Nigeria and nominee for the position of Chief Justice of Nigeria, Honorable Justice Walter Samuel Ekano Onoge, CFR. My Lord, you are welcome to the Red Chamber. We've all been given a copy of his CV, which I think you've had the opportunity to go through. As our practice, my Lord, will allow you first to tell us a bit about yourself, and also if there are things in your CV which has been omitted, which you think would be relevant for us to know about, you can say that. And after that, I'll ask my colleagues that have any questions to ask you the questions, and then you respond. The questions will be from our colleagues, and if there are any questions you're not clear about, you do let us know so that they can say it again or repeat it as case may be. This is a judicially friendly chamber, so please feel relaxed. Over to you, sir.
The Senate President, Deputy Senate President, Senate Leader, the Minority Leader, distinguished senators, gentlemen of the press, good morning. It's a great pleasure to attend this session in this capacity. I have had to be coming here accompanying former Chief Justices of Nigeria for their screening, right down from Honorable Justice Belgore, only that of Justice Mahmoud Mohammed I couldn't attend because he specifically gave me permission to represent him at NJI function on the date of his screening. My name is Walter Samuel Nkano Onoge. I was born at Okurike village in Biase local government of Nigeria, or Cross River State, Nigeria, on the 22nd day of December 1950. I attended primary school in the village Presbyterian Primary School. I later on joined my father in Ghana to continue my education. I was at Odogono Boys Secondary School at Abraka, Accra. I had my first school leaving my school certificate in 1972 in that school. I proceeded to Accra Academy, where I did my higher school certificate. I completed it in 1974, gained admission into the University of Ghana, Legon, where I read law. I had my LLB Honors second class upper in 1977. Then came to the Nigerian Law School for the mandatory 9 months professional training, which I completed and was called to Nigerian Bar in 1978. Thereafter, I went straight into private practice. I did my youth service in the Lagos State
Ministry of Justice. From there, I went straight into private legal practice with the late Tuomi Ifemekong, a senior advocate of Nigeria, of blessed memory. That chambers is still there, and it happened to be the first chambers in Cross River State to have survived the death of the principal partner and head of chambers. It's still in existence. I continued with that chambers until 1988, when I left to establish my own firm, Walter Nogin and Associates, at number 104 Calabar Road, Calabar. But in 1989, I was invited to be made a judge. I left the chambers for my junior and went to be a judge of the High Court of Cross River State in 1989. In 1998, I was elevated to the Court of Appeal while sitting as a tribunal, Fairbanks Tribunal in Ibadan. So I was elevated to the Court of Appeal, sworn in, and posted to the Lorraine Division of the Court of Appeal, which was then just being established. I was one of the pioneer justices who established or who started it. I stayed there for about 7 years almost. Then was posted to Lagos, transferred to Lagos. It was from Lagos in 2005 that I was elevated to the Supreme Court, and came down to Abuja. I love farming. I write, I read, I walk. That is Onogini in a nutshell for you.
Thank you. Deputy Senate President.
Thank you, Mr. President. Very distinguished colleagues. My Lord, I would like to join the Senate President in welcoming you and also to congratulate you on your nomination. I also welcome your colleagues who have accompanied you. I have three short questions. The first relates to the time frame within which politically related matters are dealt with. My Lord, I'm sure you're aware that prior to 2010, election matters take 4 years, 5 years to conclude, sometimes beyond the lifespan of the tenure of the incumbent. But after we amended the Constitution, giving time frame to deal with that, some other parts of political related matters got caught up in the web of long periods of trial. Now, matters such as the internal dynamics of the party, post-election, pre-election matters, they are pending all over the courts and taking so much time to deal with. Is there any way you think that those politically related matters can be dealt with expeditiously? The second relates to the issue of corruption. My Lord, there's been this argument whether there should be separate courts for corruption-related matters. And it appears that the judiciary has been reluctant in supporting that move. As the head of judiciary, what do you think should be the way forward in determining whether to set up separate courts for corruption matters or to allow the regular courts to continue as they are doing? And then finally, sir, we all believe that the judiciary is the last hope of the common man. But with the present searchlight on the judiciary by the anti-corruption agencies, people are worried that we may get into a situation where the courts are intimidated in such a way that even the common man cannot be sure of justice. So what's the guarantee that in spite of everything, that the judiciary will remain resolute and determined to ensure that they remain the last hope of the common man?
Leader of the Senate.
Thank you very much, Mr. Chairman, very distinguished colleagues. My Lord, I will ask a question of a general nature because I'm not a lawyer, but let me congratulate you on the nomination. A quick comment before the question. We all believe that we have three arms of government. And of course, we enjoy our independence to some extent. But we make laws and we interpret them in the judiciary. I want to suggest that we should build a closer working relationship. That is the legislature and the executive, the judiciary, because we need to understand how you think. And we also, you need to understand how we operate. Most of your reforms start from here. In fact, we make the laws to reform. So I want to suggest that during your tenure, try to make maybe a closer relationship, and let's hope that that makes your work better and more successful. My question is, recently, there were some cases, corruption charges against some of the people that work in the judicial arm of government. You have about 4 years to be the CGN. I want us to tell us how you intend 3 years? It's more than 3 years. It's almost 4 years. My Lord, please tell us how you intend to, within this period, reform the judiciary, bring back confidence of public, because some people will feel our judicial system is under heavy question mark of integrity. It is an allegation, but we need to do something to regain confidence of the public. With this, I want to thank you and wish you good luck.
I think you take those two questions.
Much distinguished senators, Senate leader, and the Deputy Senate President. Time frame within which to handle political matters. If you look back, you will see, and to the present, you will see that there has been tremendous improvement in that respect. Today, for instance, being Wednesday is set aside for a special panel of the court, the Supreme Court, to deal with pre-election matters. You will sit in your regular panel. Then on Wednesday, another panel that had sat earlier will sit to handle these matters. The intention is to obviously to try as much as possible to finish with them so as to give the politicians the opportunity to carry on with their duty of governing the states or wherever office they are aspiring to, without always having this kind of distraction. But it's at a very tremendous cost to the court, to the system. That is true, because the normal cases are there, these other ones come in, and we're giving them expeditious hearing because we believe, being election-related matters, they ought to be heard expeditiously. So whenever they come to the Supreme Court, we've been dealing with them that way. And so far, I've enjoyed the tremendous cooperation of the justices, and there's much improvement. I will confess that today they are not sitting because they are all here. But I don't think today's absence or lack of sitting today will adversely affect the ultimate result. So we are doing everything possible to try to, on our side, try to remedy the situation. Yes. You asked whether there is need for a separate court. Already, as I came on board, for instance, I had to really try to understand what is going on. Is it really some problems that are really outstanding? So I have had to send circulars to all the heads of the Nigerian judiciary in the country to send me details of pending matters on corruption, matters on terrorism, high-profile criminal matters, in terms of banking that affects the economy, EFCC matters, ICPC matters, and for explanations to be offered as to why they are being delayed and things like that. So I've gotten this data, I have gone through them, and I've been able to identify certain problems that need to be addressed. In terms of election, separate courts for corruption matters, I don't see much of the corruption matters as such, but they are there. And from the explanations they have given from the database, well, I believe it takes three to have an effective and efficient judiciary. Criminal prosecution, for instance, you need to have an effective and efficient investigator who will investigate first before charging you to court, gets his evidence. You need a prosecutor who will go through this, when the investigator brings this report to him, he should go through it and decide whether it has any weight. Then you have the judge, who is the final piece of the puzzle. So when matters that get to court that are properly are ready for trial, actually you normally see them moving from day to day and expeditiously. So actually it is the government. If the government wants to establish any court and how many courts, the judiciary wouldn't say no. But I believe if we can put our acts together and do the right thing, carry out proper investigation before charging a man to court. And when you get there, be ready to prosecute your case, because the judges are always there. But there will be adjournments, most often not at the instance of the court. So the decision has to either go by way of establishment of a specialized court for corruption, or not, or continue this way. Because if you don't improve that system, it will not make a difference whether you have very many specialized courts for that. That is my take on that. Then corruption, yes, corruption in the judiciary and the independence of the judiciary as they relate. Judiciary is part of the society. We all agree there's corruption everywhere. And you would have also realized that efforts have been put in place, are being made to check it in accordance with the rules and regulations put in place. So the problem comes in when you don't adhere to the rules, because the judiciary deals with laws, the Constitution, the laws and the regulations, and it shouldn't be seen to be acting outside the purview of these regulations. So within that compass, I assure you that we have strong-willed, determined judicial officers of unquestionable integrity that have put in all that they have in the service of that arm of government. And I believe that the Nigerian judiciary will come out of the present situation stronger than ever before. Then there is a suggestion, okay. It is a very good suggestion that there should be a kind of cooperation between the legislature and the judiciary. In fact, it should equally be extended to the executive, because these three arms belong to one body, the government. The government is made up of these three arms. So there should be some understanding between them, because some of the problems we face are not really worth it if they are subjected to a little bit of discussion here and there at certain levels. So it could be, on my part, I would encourage it, but not to the extent of compromising the integrity of the judiciary, because the judiciary remains the last hope of the common man. In fact, everybody is a common man in the eyes of the judiciary. That is why that lady is blindfolded. He doesn't see who is coming. He doesn't need to see him. Yes, the corruption charges, I have answered that in the way I dealt with the other district. So the charges are there. Well, they are being tried and being sub judice. I think you will excuse me not to comment on that, so that I would not be liable for contempt proceedings. Thank you, Mr. President of the Senate.
Senator David Moore.
Thank you, Mr. Chairman. My name is David Umaru. I represent Niger East. Let me seize the opportunity to congratulate His Lordship for the nomination. I have just a few questions. One, you recall the case of Buhari against INEC and others, 2008, SC 51/2/2008, in which you delivered a dissenting judgment alongside your brothers, wherein you nullified the election, 2007 election, on the grounds of substantial non-compliance with the Electoral Act. You equally handed down the profound decision in Amechi versus INEC, reported in 2008-5 Nigerian Weekly Law Reports at page 1080. Equally in the case of Saraki against the Federal Republic of Nigeria, delivered on 5th February 2016, you delivered the lead judgment there. That scenario put against the recent arrest of some judicial officers for alleged involvement in corrupt practices. And following the delay in your nomination by the executive, sending the name here for confirmation, there is a general feeling that the judiciary under your watch, if eventually the nomination passes through this distinguished Senate, that the judiciary under your watch may not exhibit the exceptional and uncommon courage which you had exhibited in those two cases, as to ensure the independence of the judiciary. How can you assure Nigerians that should your confirmation be confirmed, the independence of the judiciary under your watch will not be compromised? Secondly, Mr. Chairman, recently, of course I am. Thank you.
By who? Who are you?
By
Recently, Mr. Chairman, pursuant to Section 231 of the Constitution of the Federal Republic of Nigeria as amended, you invited nominations from the Nigerian Bar Association to nominate suitably qualified legal practitioners for appointment as justices of the Supreme Court. Similar invitation was extended in respect of the Court of Appeal. Could you explain the reason behind this departure from tradition of elevating justices of the lower court to the Supreme Court and its likely effects on the morale of judicial officers who aspire to build a career in the judiciary, and how this will impact on justice delivery in this great country? Finally, Mr. Chairman, one last question. The Presidential Enabling Business Council, PEBEC, recently approved 60 days National Action Plan for ease of doing business in Nigeria. In what ways would the judiciary under your watch key into this policy and support and ensure that ensure speedy disposal of commercial disputes to attract foreign investors? Thank you, Mr. Chairman.
Mr. Chairman, my distinguished colleagues, thank you for my name is Godswill Akpabio. I'm the minority leader, the vice chairman of the Judiciary Committee on Legal Matters by the grace of the Senate President. First of all, let me congratulate the nominee for finally coming before the Red Chambers, and congratulate Mr. President for finding you fit to take over and to maintain the tradition of the Supreme Court and the judiciary in ensuring that the most senior amongst you become the CJN, which had been the norm before your emergence. I must also say that, judging from your record, that you had a fantastic pedigree in terms of uprightness, in terms of integrity. And for this, I believe that those attributes will come to bear in your tenure, whether it is 1 year or 3 years or 4 years. So I look forward to having a fantastic judiciary, a reformed one after your tenure. Congratulations in advance. But today, Nigerians are very worried about the judiciary as a whole, just like we are worried about every other thing. My colleague has already said that your nomination was delayed, but it's not been your nomination alone that have been delayed by the present administration. I know that even the appointment of ministers was delayed far more than yours. So it really doesn't matter what time you come before us. What matters is that you are now here before us. The President, the worry I want to ask is almost like a small story, but it's not going to be long. You permit me. The leader is speaking. The minority leader is speaking. The Senate leader will protect us. I want to be protected. Mr. Chairman, I want to be protected. Thank you. The chairman has protected me. Thank you for your protection. Yes. So if they are listening, they may not need to ask further questions. So one of the problems I have is that mine is actually how are you going to reinvigorate the confidence of the public in the judiciary based on the fact that we have had instances of same facts, with the almost, in fact, same facts coming before through courts and divergent decisions emerging. For instance, the public seems to have more confidence in the Supreme Court than in all other courts below the Supreme Court. That is a fact. I'm saying this especially, okay, let me not be too specific. Why I'm mentioning this, sir, is that take for instance, very recently, we had a situation in Port Harcourt where we received judgment. And of the 3 justices of the Court of Appeal that sat, 2 of them emerged with handwritten judgments in a very crucial matter. And they read their handwritten judgments within 10 minutes each. And so they carried a day. But the minority judgment took 1 hour 45 minutes and did a thorough job of picking on the issues one after the other to the amazement of all. When we see such a thing, it tends to give the impression that this particular handwritten judgment of 10 minutes, 5 minutes, were afterthoughts. Nigerians want to see an independent judiciary. So far, we believe we are doing a good job under the circumstances. With your confirmation, sir, how are you going to give us an independent judiciary where the other judicial arms below the Supreme Court, Nigerians will have confidence in them? I'm saying this because it concerns us in the Senate. Our decisions. Okay, I have asked the question of the confidence in courts below the Supreme Court. How are you going to do that to ensure that such confidence is reinvigorated because of the kind of shocking decisions that come out in courts below you? That's one part of it. The other aspect, sir, is that we believe strongly that the Supreme Court is overworked. And if the Supreme Court is overworked, I know that we allow you the opportunity to have, the law allows you the opportunity to have up to 21 justices in the Supreme Court. But as of today, we do not have more than 17. I don't know whether under your chairmanship, the National Judicial Council will consider filling the other gap in order to have more panels that can deal with cases. As of today, I also know that you are yet to really fully go into 2006 cases that had to do with commercial matters. And this does not give confidence to investors who are coming into Nigeria if their cases are over-delayed. Then finally, sir, from the side of politics, we believe that the judiciary can help us to strengthen democracy. And we are worried right now that the judiciary, yes, is an arm of government, but we don't want the judiciary to be pocketed by a political party. Because I do know that when we had the opportunity of being in charge for over 16 years, the judiciary had a very independent judiciary, and a lot of decisions that came out were not politically motivated. Am I speaking your mind? Yes, yes. So today we are worried that we like to say, no, I don't want to mention names of judges, but we want to see more action on your part in dealing with issues where clearly a judge will put himself in the arena and deliver, give decisions that even the plaintiff will not ask for, including adding a wife to the plaintiff in his ruling, and then personalizing issues as done very recently. So that we are worried, and would like you to see sanitization. What reforms are you going to bring? How are you going to talk to the courts below you? And at the same time, sir, we have confidence in you. We have confidence in the Supreme Court. We want to have confidence in the Court of Appeal. We want to have confidence in the High Court and all other courts below you. Congratulations on the elevation. Thank you.
Now let me take those questions here.
Thank you very much. On the question of of delay in my appointment, subject to confirmation, because the nomination had already been done by NJC. That one, I can't tell. But eventually, it was done. And here we are today. So on the fear of me not exhibiting the uncommon courage that had earlier been exhibited, I assure you that I remain who I have been on the bench right from the beginning, and intend to end that way by the special grace of God. I believe that you don't need to see a judge before you can have justice. I also believe that it takes two to have a dispute, and I know that both of them don't have the same story to tell as to the reasons for that dispute. The judge comes in to try to apply some rules to determine which of the two could be the likely person to be right. And I believe if we all know that both of us who have dispute and approach the court can never walk out of that court as winners, that one must win and one must lose, that the stronger case will always be the decision of the court, then the better for all of us, the better for the judiciary of this country, and the judiciary of any nation at all. But when we approach the system and thinking that, oh, there's always something wrong somewhere and things like that, that is where the problem lies. So that is why I wouldn't say more on that. I'm sure that so I assure you that the independence of the judiciary will be continue. The independence of the judiciary will continue, and that under my watch it will be reinforced. That one is there's no compromise on that, because you see, I said it earlier. If you don't have an effective and independent judiciary, you cannot talk of the society itself. If you say that the judiciary is the last hope of the common man, it's the last hope of every man, because justice is blind. It doesn't look at who is coming, common or uncommon. So, yes. Then the question of MBA, the system had been there, you see, but there are some talks. I shouldn't be allowed to answer this question because there are arguments for and arguments against. At the moment, there are arguments for and arguments against. So, as an umpire, I should reserve my opinion to when the decision is going to be taken at the appropriate time. But I want to tell you that if there is no lawyer, there is no judge who is not a member of the bar. There is none. Every judge is a member of the bar. But joining the bench is where you have age differentials. So if you are a member of the bar and you make 10 years post-call, you are qualified to be a judge of the High Court. If you make 12 years, you are qualified to be a judge of the
My Lord, I thought you said you wanted to not answer the question. I just wanted to remind you.
So, 60 days, we are already, I had a complaint. I had a courtesy call from a group that deals with these commercial matters, talking about the delay in commercial matters. So, but I want you to know that we have in place practice directions, even in the Court of Appeal and the Supreme Court. But when they came in and made that complaint, I called for the records. And to my greatest shock, the cases they were talking about had not yet landed on the Supreme Court bench. They had not gotten to us. So whether they are in 2016, they have to travel to our court. When they come to the Supreme Court, we already have in place a machinery to expedite their hearing and determination. So we are ready, we are prepared for that innovation. The conflicting judgments, the conflicting judgments they are bound to happen, because when you sue before Judge A in Abuja and you go to Sokoto and sue before Judge B, different party but on the same subject matter, and you file your processes in Abuja, not the same processes but different processes in Sokoto as that lawyer sees it, the judge in Abuja may decide to allow the application, while the one in Sokoto may decide to dismiss it. Now, the system has its own regulatory mechanism through the means of appeal. That is how we resolve these things. But to think that we can do away with conflicting judgments in a judiciary, every judiciary in the world, is not going to be possible. So that is that. But the aspect of the particular case he's talking, I think the matter is still sub judice, and I should be excused from commenting on it. So 21, okay, the appointment, that is taken care of by what I said earlier on in terms of making the number up. I can say that there are moves to make it up, the required number. We are looking into that. So pocketing the judiciary, as I've said, is not going to be possible. It has never been possible, and I don't think it will be possible under my watch. Because as I said, that will be the end of this country as you know it. The moment you politicize the judiciary, then you finish it. Everything is finished.
Senator Oji.
Yes, exactly.
I want to answer it by telling you that there are, whether you are son or whatever, you are a lawyer first. And the law has set out how you can become a judicial officer.
Senator Oji.
Thank you, Your Excellency, for the opportunity. I want to say that my questions have been answered. Senator Umaru asked most of my questions. Thank you. Lordship, you are welcome.
Thank you very much, Mr. President and my distinguished colleagues. My Lord, the nominee, my question is, one of the greatest exhibitions of the function of judiciary is the recent happening in the United States of America, where the judiciary came to the aid of the entire country by timeously addressing certain decisions that certain people found to be unconstitutional based on the United States Constitution. And they approached the court, and the court became decisively definitive. And that led to rest what will have been a very serious international crisis. Do we expect a judiciary under you that will possess the capacity to exhibit this kind of rare position as far as issues that relates to certain reckless decisions of the executive are concerned? One. The second one is the issue of, again, appointment of judges. We all knew what brought us to where we were, or where we are today, sorry. Certain considerations that have remained sacrosanct as the deciding factors for appointment of judges of the High Court and justices of the Court of Appeal and up to Supreme Court were slightly compromised. And therefore, we unfortunately found from amongst us very few individuals whose conduct has brought very, very disturbing impact on the integrity of the institution. Do we expect a program that will equally decisively address those issues so that we can shield the entire institution from what it is going through at the moment? I hope I have made myself clear.
Chief Whip. Thank you very much. I have 3 quick questions. And on behalf of the non-lawyers, I will show that non-lawyers can ask questions with better brevity than the lawyers with long experience. Question number 1, sir. When I go to a court, I feel great sympathy for judges. They have these old papers, old pen, and they're writing everything longhand. And one person, they will spell names because the name may be from a different ethnic group. The process itself almost numbs the mind. And I want to ask, under you, is there a way that we can modernize the court process? Because when you get to the UK and you get to the US, you don't find judges with pen, long writing everything as if they are stenographers. How can we modernize the process of taking notes in the court? Secondly, the question is asked to the nominee, not to judges from Delta. Second question. The case has already been mentioned here. There are too many cases in the Supreme Court. I believe that there are not just too many cases in the Supreme Court, that the justices of the Supreme Court are involved in business that ought not to be their business. And I'll mention one. When Queen's Counsels are appointed in the in the UK, do we have members of the Supreme Court of the UK involved? Why are members of the bench nominating and getting involved on who should be SAN? Because you have some sand boasting about the whole place that they have the support of this or that member of the Supreme Court before whom they will eventually appear. Can we have sand emerging solely from members of the bar? Once you say you are moving from the bar to the bench, leave the seniority of the bar alone. Last question. I'm glad that someone made the point that we will have close to 4 years as the CJN of Nigeria if you are confirmed. I'm glad because the Chief Justice of every republic or non-republic is also an activist judge who can choose to be restrictive or liberal in the interpretation of the laws that come from the legislature. And I'm sure you know that very well. But if you have only 3 months or 6 months, no matter what it is you want to achieve in terms of reform, it takes time. And that is why I believe this gerontocracy, which the Supreme Court has become, because unless the man ahead of you dies or chooses to retire, you have no chance of becoming Chief Justice, even if you are the brightest on that bench. How can we therefore temper this conservative tradition? I have a right to ask my question. I have a right to ask my question.
When you have your own question, you have. How can we temper this? Yes. Yes. Because you also have to remember this is not the only jurisdiction in the world. This is not the only jurisdiction in the world. There are other jurisdictions where things are done differently and there are better justices. So my question to you, Mr. Nominee, is if we continue to have it only by seniority, you get to that post so late that you can't even carry out the reform that you want to carry out. That's my question. Thank you.
Take this set of questions.
The recent happenings in the U.S., I just want us not to forget so quickly what the Nigerian judiciary has been doing in the past when confronted with similar problems. Even before the coming into being of the present administration, there were steps that the judiciary had to take to preempt or prevent chaos and anarchy. There, secondly, the system that operates there is not the same system we operate here. They had given their judgment, and immediately Mr. President obeyed. If he didn't, he sought constitutional means of avoiding it. So you ask yourself, are you ready for that? If you are, then the system, the judiciary is always there, is ready. And don't forget that you must approach the court. The court does not come to you. You go to the court, you approach the court, lay your complaints before the court, and then the court will deal with it. Now, on the appointment of judicial officers, modalities leading to the appointment of a few undesirable elements. You see, I've read that in the pages of newspapers and things like that. I am not privileged with that kind of information. So I don't think I can help you with that. Because definitely it's a privileged information. But as far as the system is concerned, the MJC is responsible for dealing with and disciplining judicial officers. And if anybody has information about a judicial officer who has abused his oath of office by misconducting himself, and he comes under our rules, backs it up with the relevant documents and affidavits, I assure you that the NJC had never fallen shy of discharging its responsibility in that respect. I can't be speculative in that thing because we need to be very, very specific and cautious because we are dealing with the integrity and the reputation of men and women who have no privilege of talking back. So that is my take on that. I don't think it was a result of reckless way of handling the appointment exercise. No. There may be some that may escape, but when you point them out and we get hold of them, we have always shown them the way out of the system. So then there is the modernizing the judicial process. Yes, it has started in earnest in the Federal High Court and the National Industrial Court and other high courts. And then even in the Supreme Court, we have the retrofitting project that ought to have been finished by November last year, but it's ongoing. Very soon, when it is fully completed, everything will be, even the lawyer may not necessarily be in the court. It can be anywhere. You are doing your business. So we ourselves, we don't want to continue to write in longhand. And so we are trying even to be computer literate. but that one too affects our sight. We are not getting younger. So there are some advantages and disadvantages too. So appointment of senior advocates. Now, the system, as you all know, was borrowed from the United Kingdom, where you had the King or Queen's Council, depending on who is seated on the throne of England. So we had them brought in here. It is not the justices of the Supreme Court that appoint senior advocates of Nigeria. No, there is a body chaired by the Chief Justice of Nigeria, known as the Legal Practitioners Privileges Committee. That body is responsible for the award of that rank in Nigeria. Now, the justices of the Supreme Court come into the equation because lawyers appear before them. So they can now comment on the applicants, either while they were on the High Court bench, the Court of Appeal, the Supreme Court. So that is how they come in. If the bar feels that, but if the legal profession thinks and sees the need for removing it from the purview of the Legal Practitioners Privileges Committee, they will do that. But if the bar is to give itself that rank, I don't think it will be appropriate. There must be a higher body that should confer that rank. It's like you have the Council for Legal Education, responsible for training of lawyers. You have the body of benchers responsible for calling the new wit to the bar and disciplining them. Then you now say the bar should do this other thing. The bar will be incapacitated. The disciplinary committee of the bar is an arm of the body of benchers, which is the highest organ in the profession. So that is my take on that. The conservative system of appointing the Chief Justice and things like that, I think you should spare me that. Let me not answer that because it's not a one-on-one kind of question. It's something that involves the totality of that profession. They have tested this side and they have tested this side. They should be in a position to know which one serves this country better, knowing fully well that it is not safe to politicize appointment to the bench. It doesn't matter whether it's in the High Court, the Court of Appeal, or the Supreme Court. The day you do that, you succeed in doing that, then say bye-bye to this country, because there will be no independence of the judiciary. Everybody will be clamoring for his candidate. There will be lobbying everywhere for appointment. Thank you.
Senator Samayo.
Thank you, Mr. President. Very distinguished colleagues. My name is Senator Sam. I represent Imo East in Imo State. This morning, Mr. Chairman, my Lord, I want to congratulate you. My name is Samuel, and I know that you are Samuel too. God called you 3 times like me. My Lord, my question is just very simple. I was being asked by my constituents who heard that you are coming for screening today. They asked me to ask you, sir, is it right for INEC to issue a certificate of return to anybody on the order of a high court in a pre-election matter when the victim of such a judgment from the lower court is entitled for an appeal at the appeal court and the Supreme Court? That's my question, sir. Thank you.
excused because it is coming up. It will be, from there, it will go to the Court of Appeal, an opinion will be expressed, then it comes to the Supreme Court. I might not even be on the bench. That may decide it. Thank you.
Senator Abdullah Dambaba.
Thank you, Mr. Chairman, my distinguished colleagues. My Lord, my question is this. Corruption, to my mind, is an attitude of the mind. But the judiciary is one of the most important institutions that can be used to fight corruption. Now, in recent past, we have witnessed judgments, conflicting judgments by courts of coordinate jurisdictions. What institutional reforms do you intend to bring in order to arrest this kind of ugly situation and bring back the integrity of the judiciary? That is my question, Mr. Chairman.
Let's try and ensure that we do not repeat questions already been asked. Senator Magnus Abbey.
Thank you, Mr. Chairman, my very eminent and distinguished colleagues. My Lord the nominee, let me first of all congratulate you on your nomination. Contrary to those who see the delay in your nomination one way, I see it as a very, very positive endorsement of your character, because it means that the president took his time and did not just nominate you because you are the oldest Supreme Court judge. If he was doing that, he would have done it long ago. But in view of the challenges that the judiciary is facing currently, he took his time, examined you, and then nominated you. So I congratulate you. But Mr. Nominee, sir, all is not well with the judiciary in Nigeria today. There are serious challenges facing the judiciary that has eroded the confidence of the average Nigerian in our judiciary. One of those challenges, sir, is the question of time. How long cases take in our judicial system. If you look at the example that my brother Senator Nala gave about what happened in the American judicial system, it didn't take the judiciary up to 48 hours to respond to what was clearly an emergency issue in the American system. But in Nigeria, that same issue would have taken us 2 years of laboring through the system before we will get a conclusion from the judiciary. Another thing too that is eroding the confidence of the average Nigerian in the judiciary is the question of precedence. I am a lawyer. When we started our practice, by just looking at earlier decisions of the Supreme Court, you could tell a client exactly what will happen to his case. But today, in today's Nigeria, you can have 10 Supreme Court decisions on a single issue, and people will still go to court and still get a different decision right from the High Court all through the Court of Appeal, and even sometimes up to the Supreme Court itself, where our own precedent is not followed by any of the courts. This particular issue has greatly eroded the confidence of the average Nigerian in the judiciary. The other issue I would also like to raise, Mr. Nominee, sir, is the question of the disobedience to court orders in this country. Except we are in a position where we can actually assure our citizens that the judicial process means something, and that an order of the court is an order of the court, not subject to review by any other authority in the land, and where there are consequences for those who step out of their way to disobey an order of the court. it will be very difficult to restore the confidence of the public in the judicial process. So what can you do about some of these issues that are affecting the judicial process in this country? Thank you very much.
I will start with you, learned distinguished senator and learned gentleman. Disobedience to court orders, that shouldn't, that is a problem for the legislature and the executive to handle. The judiciary will welcome that day, that great day, when in this country a decision is handed down by a court of competent jurisdiction, and even after its appeals had been exhausted, the rights of appeal had been exhausted, the order is carried out. That is the only day that the judiciary will truly become independent. See, otherwise it's just, a judgment is a piece of paper. If it cannot bite, the judgment must back and bite. That is the truth. So disobedience to court orders and things like that is a culture, is one out of the culture of impunity anyway. But I said you should excuse me not to go into that, please. Then judicial precedent. Judicial precedent. You know, I wish lawyers, practicing lawyers, will stay back, remember their training, and put it into practice. The processes are guided by precedents. That is what guides not only the judge, but the lawyers. When a lawyer knows that this is the trend of authority, list of authorities, on a particular subject matter, but he decides to just do anything, he crafts, in order to exhibit his intelligence or skill, he crafts a case trying to make it appear different from the norm. And then he starts to, the moment we do away with precedent, then the system collapses. That is why you have a tool in the process of litigation, which is distinguishing. You have to distinguish one case from the other in order to satisfy that court that precedent does not apply to your case. And some of it is a problem of the lawyers actually. Some of you assure your client that, look, I'll get you judgment. There's no way this court can decide otherwise. Are you really sure? You are not the judge. And the principles are there. We go by precedent so that whether we are alive or dead, the decision can be analyzed by generations yet unborn. And it should be found to be sound on the law and the facts. So when you talk, I'll tell you our experience, a bitter experience in the Supreme Court, in the political cases. You go to court at the election tribunal, you have the party and the candidate as a single party, retaining one counsel. A judgment is given. Then they go to the Court of Appeal. Split the parties. The party now has its own counsel. The candidate has his own counsel. And they have different appeals. And then in between, there are cases we have seen 7 appeals arising from one judgment. And it starts from the Court of Appeal. So some of the conflicting decisions you see are when the panel is not careful enough, or the court is not careful enough to look through and see through the gimmicks, then you will have the conflicting decision. And I said that the conflicting decision is actually normal in adjudication. That is why we have the Court of Appeal and the Supreme Court to take care of such things. So when you come to the Supreme Court, what we now do is we gather all those appeals relating to that judgment, and put them together, and then ask you to now tell us what your wahala is. Yes. See, because the intention is to continue to mess the judiciary, to mess the place up and things like that. It is not fair. Some of you know that the appeal should stop at the Court of Appeal, but you will find a way of bringing it to the Supreme Court. What for? That is why nowadays too, we say, okay, if you are here on the Supreme Court bench, wasting our time on a matter which should not be here, you should be personally responsible for the cost of the proceedings. Yes, because it means you are not advising your client properly. So, any other?
Senator Obina.
No.
For what now?
Enlightened by some of the views expressed by the nominee before us. And I'll now put it to, if it's a wish of my colleagues, that during his presentation he can take a bow and leave. Sitting nominee, you can come and take a bow.
distinguished colleagues, can we take our seats? Distinguished colleagues, please take your seats. Distinguished senators, 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 please take your seats.
Senator Abdullah Adamu, take your seat.
Distinguished senators, please take your seats.
Senator Abdullah Adamu, please take your seat.
Senator Yobe, please don't disturb the Senator Adamu. Distinguished senators, please take your seats. Senator Mao, please take your seat. Senator Orji, please take your seat. Mr. Wanyanwu, please take your seat. Distinguished senators, please take your seats. Senator Nala, please take your seat. SP December is set to rule. Distinguished colleagues, the Senate President is waiting for you. Distinguished colleagues, the Senate President is waiting for you. Distinguished colleagues, please take your seats. Please take your seats.
Deputy Whip, sit down.
Mr. Chairman, sir, the Committee of the Whole is back.
Distinguished colleagues, we'll take if anybody has any questions before I put the question. Any comments otherwise? Yes, Senator Isamisa.
Thank you, Mr. President, my distinguished colleague. I am Senator Issa Hamma Misau, representing Bauchi Central. Mr. President, during the screening, I was raising my hand to make a point concerning what the senior advocates of Nigeria, they are charging. They are charging we politicians hundreds of millions. They charge 50 million, 100 million, some even 200 million. And what I wanted to ask the Chief Justice of Nigeria, that what is his salary? What is the salary of the president? How can a senior advocate of Nigeria be charging that money? And now you are paving way for them to become Supreme Court judges
appeal court judges? Which kind of money, people that are already used to money? How do you expect them to dispense justice, people that are used? So I'm asking that we must tell the Chief Justice of Nigeria, they must find a way of regulating the money the lawyers are collecting. If not, there is no way this corruption will go. Because there is no way as a politician, somebody will charge you 100 million, 200 million, and you expect that politician to have his justice. So I wanted him to ask that question. Yes, now.
Senator Bisawa, your points are well noted. They are well noted. Any other comments? If not, yes, Senator Ben Bruce.
Mr. Chairman, distinguished colleagues, my name is Ben Bruce, representing Bayelsa East. The question I wanted to ask was whether there is a mechanism to regulate corruption in the system. For instance, I know of a case in the Lagos High Court in Lagos, a simple land matter case that has been adjourned for 10 straight years. Now, if a simple case gets adjourned for 10 straight years, the internal mechanism could have found out what the problem was with that particular judge. And I can give you a simple example. A few years ago, the US Embassy had a guy who was giving visas. State Department investigated him. They found out that 90% of the visas he issued were to women only. Women only. They found out the corruption in the system. They recalled him back to Washington and appropriately punished him because they had an internal mechanism that deals with these issues. So if a judge gives adjournment for 10 straight years for a case that should take 5 minutes, it is not rocket science. Surely the system would have found out that this judge is corrupt or this judge had a mental problem and removed from the system, instead of punishing millions of people who have to appear before this particular judge. And I'll be more than happy to provide the name of this judge to His Honor at the Supreme Court. And that's the question I wanted to ask.
Senator Bina, you put your hand? Yes.
Thank you, Mr. President, distinguished colleagues. Obi Noba is my name. Mr. President, I wanted to raise one issue as it concerns suspects. When a suspect is sick and they'll be pleading upon pleading for such suspect to be allowed to be treated, the executive or so-called, they will never allow such suspect to be treated. For example, it happens to the former governor of Niger State. They were hammering that this man was sick, they should be allowed to be treated. When the man was in danger list, he was asked to travel, and along the way, he died. There are so many people now in Nigerian cells that are complaining of sickness, one thing or the other, and efforts are being made for those people to be allowed to be treated, and nothing is being done about it. We have lost so many people like that, and if nothing is done, Nigerians will continue to die in silence. I wanted to ask the Chief Judge, if it's confirmed and there's a court order, if executive fails to obey that order, what is he going to do? There are so many orders from court of competent jurisdiction. Nobody has obeyed that order, and nothing has happened in this country. What kind of country is this? Mr. President, there's need for us to do something about it. Thank you, Mr. President.
Distinguished colleagues, maybe at this point I'll now put the question. Will the Senate approve the nomination of Honorable Justice Walter Onoge for appointment as Chief Justice of Nigeria? Those in favor say aye. Aye. Those against say nay. The ayes have it. Leader of the Senate.
Mr. Chairman, distinguished colleagues, I move that the chair reports progress.
Mr. Chairman, distinguished colleagues, I rise to second the motion moved by the leader that the chair, we revert to plenary to report progress. I so second.
Distinguished colleagues, those in favor that we report progress say aye. Those against say nay. The ayes have it. Distinguished colleagues, the Senate in the Committee of the Whole considered the request of Mr. President CNC for the confirmation of a nominee for appointment as Chief Justice of Nigeria. The nominee answered questions from distinguished senators on judicial matters and a number of topical issues. Thereafter, the committee approved the nomination of Honorable Justice Walter Samuel Nkanu Onoge, CFR, as Chief Justice of Nigeria. Is this a true reflection of what transpired in the Committee of the Whole? I'll now put the question. Will the Senate confirm the appointment of Honorable Justice Walter Onoge for appointment of Chief Justice of Nigeria? Those in favor say aye. Aye. Those against say nay. The ayes have it. The nomination of Honorable Justice Walter Onoge is hereby confirmed as Chief Justice of Nigeria. Distinguished colleagues, let me at this point congratulate on behalf of the Senate the new Chief Justice of Nigeria, Justice Walter Samuel Onoge. The screening, the clearance, and the entire exercise taken on another milestone progress in our democratic process. We've had a real occasion today to hear from him on his views, on his vision of the judiciary, and I think he appreciates more than anybody else the responsibilities and the challenge that he has ahead in addressing the integrity, restoring integrity and confidence in Nigerian people of the judiciary. We hope on behalf of his colleagues that they will continue to ensure that the judiciary is the last resort of the common man, and also gives the opportunity also to continue close relationship with the three arms of government. We look forward to a productive relationship with the legislative arm of government for the interest of our great country. Once again, I congratulate Justice Walter Onoge and wish him a fruitful tenure as the Chief Justice of Nigeria. Leader of the Senate.
Mr. President, very distinguished colleagues, the fifth order of the day is the second. Mr. President, the fifth order of the day is the second reading of the Companies and Allied Matters Act, Cap C-20, Amendment Bill 2017. Very distinguished senators will recall that the bill was read the first time in this chamber on Tuesday, 8 November 2016. Mr. President, you may wish to invite Senator Fatima Rasaki to move the motion for the bill to be read a second time.
Senator Rasaki.
Thank you. Thank you, Mr. President. Distinguished colleagues, the bill for debate before us this afternoon is a bill for an act to amend the Companies and Allied Matters Act, Cap C20 LFN 2004 to provide for the incorporation of companies, registrations of business names, together with incorporation of trustees of certain communities, bodies, associations, and incidental matters. Your Excellency, the Senate President, distinguished senators, I seek your support while leading the debate for the second reading of the above bill. The bill seeks to amend the Companies and Allied Matter Act, CAMA, to accommodate matters emerging which were not contemplated when the act was enacted during the regime of President Ibrahim Babangida. Distinguished senators, the Companies and Allied Matter Act, CAMA, is divided into 4 parts, namely Part A, B, C, and D. It is instructive to note that Part A deals with registration of companies, either private or public. Part B deals with the registration of business names. Part C deals with the registration of incorporated trustees, and Part D deals with the schedule that guides the implementation of the Act. The amendment bill before the distinguished Senate dwells much on Part A of the Act, dealing with the registration of companies. Amendment of CAMA. The bill seeks to amend Section 2 of the Act by introducing new members to include one representative of the Institute of Chartered Secretaries and Administrators, among others. This is intended to strengthen the board to encompass relevant stakeholders and to deliver on its functions. 2, the bill also seeks to introduce new functions for the board of the Commission, in addition to the functions of the Commission already contained in the Act. The novel ideal is intended to make the board more responsive in carrying out its functions to its clients. The bill also seeks to amend Section 18 of the Act to allow one person to be able to incorporate a private limited liability company by complying with the requirements of the Act in respect of a private company. The bill seeks to amend Section 26 of Act of the registration of a company limited by guarantee to admit for reasons in the event of any objection to the registration of the company as limited by guarantee. The bill also seeks to amend Section 27 of the Act, which deal with the requirements for memorandum of a company. The share capital is to be increased from 10,000 to 100,000 in the case of a private company, and from 500,000 to 2 million in the case of a public company. This is intended to create confidence in companies doing business in Nigeria in view of the current realities of high inflationary rates, which has drastically reduced the value of the naira. Section 32 of the Act on the reservation of names is to be amended to allow for reservation of name through hard copy or electronic communications. This is in line with the development in the information technology. Equally, fines imposed for default in the alteration of business or object clause is to be increased from 50 naira to 5,000. The bill proposes a holistic amendment on fines and penalties imposed by the Act so as to bring them in reality with the current value of naira. The bill introduces and vests the power in the President to exempt foreign companies from complying with the provision of Section 55 of the Act. This applies to foreign companies either invited by any tie of government in Nigeria or invited for the execution of any specific loan project on behalf of a donor country or an international organization. The bill introduces a new innovation to allow companies effectively conduct their businesses by allowing them to hold their general meetings electronically, provided that such meetings are conducted in accordance with the regulations made from time to time by the Commission. The bill places on directors the duty of disclosure as to their holdings in the companies as well as their ages. The bill again introduces a restriction on multiple directorship and stipulates that a person cannot be a director in more than 5 public companies and shall be fined accordingly where he fails to disclose his directorship in more than 5 public companies in accordance with this bill. The bill also introduces provisions to make it mandatory for a company to appoint a company secretary within 6 months of its incorporation. Your Excellency, distinguished senators, the amendment of the Company and Allied Matters is important in view of the present administration's determination to diversify the economy by laying more emphasis on trade and investments. The amendment, therefore, is to provide a more conducive climate for the conduct of business in Nigeria. Distinguished senators, I thank you for your attention and wish to solicit for your support to allow the bill to be read a second time. Thank you.
Distinguished colleagues, if you could see on the other paper, this bill and also the second bill under Senator Ovioma Agege are both the same. So it would be better if we could consolidate it and get Senator Agege to also move the motion for the second reading. Leader, maybe you put the question, we accept, and then we move forward, if that's the wish of the...
Mr. President, distinguished colleagues, in the light of the similarity of the two bills, I move that we merge the two bills and so that they can be considered at the same time. I so move.
Leader.
Mr. President, my distinguished colleagues, I rise respectfully to second the motion as moved by the leader.
Distinguished colleagues, those in favor of the motion say aye. Those against say nay. The ayes have it. Senator Ovioma Agege, you lead the debate on...
Thank you, Mr. President. Senator Ovie Omo Agege, Delta Central Senatorial District. Mr. President, distinguished colleagues, confident about this Senate's constitutional powers to chart viable fronts for our nation through legislative creativity and industry, I stand with humility to present this lead debate for a second reading of the bill to amend the Company and Allied Matters Act, CAMA, and for the establishment of State Corporate Affairs Commission 2016. Mr. President, the Companies and Allied Matters Act, the Act, has not witnessed major amendments since coming into force in 1990. Even the Corporate Affairs Commission recognizes that the Act is long overdue for amendment. In a report presented at the 2015 Annual General Conference of the Nigerian Bar Association, the CAC noted, Mr. President, that the passage of time and developments in both the Nigerian and global economies have made some of the provisions of the Act impracticable and inadequate. Mr. President, this amendment bill is focused in the main on the strengthening regulatory capacity of the CAC and accountability and transparency within it, involving improving the nation's business environment by integrating the informal sector into the formal sector and empowering the state to play key roles in development of small businesses. Mr. President, this bill mandates the CAC to publish its audited statements of accounts and prescribes penalties for failure to so do. This transparent and accountable public disclosure will check and limit corruption, Mr. President. Mr. President, distinguished colleagues, it is necessary for the CAC to lead by example in terms of corporate governance. Indeed, how can we have a system where public companies under the CAC are mandated to publish their annual accounts, but the CAC itself operates opaquely in its revenues, as the CAC is not mandated to publicly publish its accounts for public scrutiny? The CAC simply prepares the statements of account as may be directed by the Federal Executive Council. Beyond the FEC, CAC owes Nigerians a sacrosanct duty to be publicly transparent and accountable with public revenues in its custody. Mr. President, it may be argued that yes, the Fiscal Responsibility Commission has statutory powers to compel the CAC to make disclosures regarding its revenues. But where the FRC fails to act, the CAC is left to act discretionarily with public revenues. This opacity is an aberration, and this is surely inconsistent with global best practices. Mr. President, distinguished colleagues, this bill also seeks to introduce a new provision in the Act for the remuneration of members of the CAC's board to be determined by the National Salaries, Income and Wages Commission. Currently, Mr. President, the President of the Federal Republic has sole discretion to determine the remuneration of members of the board. This leaves room for potential arbitrariness. The method of determining the remuneration of members of the board should no longer be left to a president with the NSIWC in existence and functional. In my humble opinion, a president ought to be too busy to be burdened with determining salaries in the CAC. Mr. President, this bill also seeks to remove undue protectionist hurdles from the part of the CAC by enabling it to carry out independent investigations into the affairs of public companies, where the interests of the investing on general public are under credible threats. In the UK, both Parliament and the courts have taken steps to ensure that the UK company regulator is adequately empowered to conduct investigations into public companies in the interest of both shareholders and other stakeholders in general public. In the case of Northwest Holds versus Secretary of State for Trade, while analyzing the basis for statutorily empowering the Secretary of Trade to initiate investigations into the affairs of a company, Lord Denny, the most famous Lord Denny, noted as follows: that it sometimes happens that public companies are conducted in a way which is beyond the control of ordinary shareholders. The majority of the shares are in the hands of 2 or 3 shareholders. These have control of the company's affairs. The other stakeholders know little and are told little. They receive the glossy annual reports. Most of them throw them into waste paper baskets. There's an annual general meeting, but few of the shareholders attend. The whole management and control is in the hands of the directors. They are a self-perpetuating oligarchy and are virtually unaccountable. Seeing that the directors are the guardians of the company, the question is asked, who will now guard the guards themselves? It is because companies are beyond the reach of ordinary individuals that this legislation has been passed so as to enable the Department of Trade to appoint inspectors to investigate the affairs of the company. Mr. President, the Institute of Directors and several other credible bodies have consistently noted that to the detriment of minority shareholders, many public companies operate in brazen breach of corporate governance principles enshrined in the Act. This impacts negatively on the national economy, as international investors tend to perceive our national investment climate as lacking the essentials of global best practices. Mr. President, the Act does not clearly empower the CAC to initiate investigations into the affairs of public companies, whose operations often carry huge public ramifications, unlike private companies. Rather, there are unnecessary obstacles working against small shareholders and stakeholders. The resultant effect is that the exercise of the investigative powers of CAC is very rare. This will not change, Mr. President, if this bill is passed into law. Mr. President, this bill further proposes an extension of the fiduciary duties of directors of companies with respect to the environment. It is elementary corporate law that the directors of a company constitute the mind, the eyes, and the limbs of a company. Section 172 of the UK Companies Act 2006 specifically requires a director to promote the success of a company for the benefit of its members, having regard to the community and environment where the company operates. Mr. President, this important statutory focus in the UK and several other national jurisdictions on a director's fiduciary responsibility for the environment of his or her company is missing in our law. This bill, Mr. President, offers an opportunity to close that lacuna. And this has become necessary because of the adverse effects of the operations of some companies on their communities and environments, which in some instances have led to breach of the peace. Mr. President, this bill also proposes to establish a State Corporate Affairs Commission to take charge of the registration of business names based on a uniform registration and regulatory legal framework and standards. This is intended to stimulate healthy competition and business climate innovations in our various states vis-à-vis their natural endowments and strategic competencies. Mr. President, for planning, security, and other demands of our federal system, this bill imposes an obligation on the proposed state commissions to share information with the CAC. Businesses registered by state commissions are to be regulated by federal government agencies where their operations require federal regulation, only where it does require federal regulation, sir. Mr. President, virtually all states in the USA operate a thriving business unit. The state of California stands out today as the 6th largest global economy. There's a strong correlation between America's robust legal framework that allows the states to undertake registration of companies and the economic health of our states. We are all aware, Mr. President, of the economic challenges faced by many of our states. We are where we are today partly because the Act, as a major corporate law in our nation, does not recognize the states at all. In the absence of a clear legal framework to stimulate competition and innovation, most states rely heavily on monthly federal allocations to thrive. That is unsustainable, Mr. President. This bill offers an opportunity to construct a solid legal architecture to encourage aggressive innovations by the states. Those who wish to succeed, Mr. President, will succeed. In this regard, Mr. President, this bill offers us an opportunity to rethink and modernize our informal sector by evolving a smart, intelligent, and innovative legal framework for integrating economic activities and incomes of the informal sector that are largely outside of government regulation and revenue generation into the informal sector. The inherent lack of structure, low and unsecure income labor movement, environment, zero employment benefits, and lack of social protection of the informal sector are compelling reasons to integrate it into the organized sector. Mr. President, with the opportunities inherent in this bill, our states will benefit hugely from a more competitive and aggressive formalization of the informal sector and businesses. The states are best suited to pursue that competitive and aggressive formalization because their prosperity depends on it. CAC has not done that over the years, Mr. President. There's no reason to believe it can do it better than the states whose survival and sustainability will depend on it. Mr. President, the registration, regulation, and growth of small businesses in the various states are very important for our local state economies and the national economy. Current government revenues derived from levies and taxes are relatively low when compared to the size of the informal sector, which is made up largely of small, unregistered business enterprises. The decentralization of registration and regulation of small businesses will put our states in a better position. Mr. President, by passing this bill, we will be tasking the states to be creative, innovative, and to operate as sustainable businesses. Mr. President, my colleagues, while this bill is not proposed as a silver bullet solution to our economic challenges, it is a right step in the right direction. This bill is important for the economy of all 36 states. A nation that is determined to have a sound economy and increase its public revenue profile must first construct a good legal framework for that purpose. This is the very purpose of this bill, Mr. President. The amendments suggested in this bill are within the legislative competence of the National Assembly. The National Assembly is not by this bill empowering the state houses of assembly to make laws for the registration of business names. Therefore, the bill does not contravene item 62F of the exclusive legislative list in the 1999 Constitution. When passed into law, Mr. President, the bill shall be applicable to all parts of the Federation and empower the governor of a state to establish a state commission to perform functions stipulated in this bill. This bill is intended to stimulate economic activities in our various states and ensure transparency, accountability, and good governance in the corporate sector. Mr. President, my colleagues, in compliance with Order 77.3 of the Standing Rules, I state that this bill has no financial implications for the federal government. Accordingly, there is no accompanying financial compendium with respect to cost of government. Mr. President, for the greater good of our republic, I hereby humbly move for the second reading of this bill to be taken. I so move, Mr. President. Thank you for the opportunity.
Deputy Leader.
Thank you very much, Mr. President, and my distinguished colleagues. First is to congratulate distinguished Senator Raji Rasaki and my bosom friend, Omo Agege, for thinking along this line. Mr. President, it is within the personal knowledge of each and every senator here that there is a redirection in the thinking
of promoting what is referred to as ease of doing business in this country. Therefore, all amendments of our laws that seek to decentralize the hitherto universal application of our laws should be encouraged. Let me state here, Mr. President, that assuming but without conceding that distinguished Senator Nala wants to do rice business only, and I'm of the opinion that I can conveniently operate in Kebbi successfully, wherein lies the wisdom of requiring me to come to Abuja or any of the zonal offices of the Corporate Affairs Commission to register a company for the purpose of farming and processing rice. It does not conform to common sense. It is even more so, Mr. President, when we, as lawyers who read company law, we remember the intricate provision that has to do with insider rule, which has greatly affected the development of our businesses in this country. And if you look at critically the second bill sponsored by distinguished Senator Omogege, it is intended to give legislative a platform for solving that problem that has continued to bedevil the growth and development of our businesses in Nigeria. To me, as intricate as the two bills look, if you look at the spirit and intent, they are simple enough to be described as straightforward enough for it to receive the blessing of this Senate for the purpose of making our own humble contribution for the ease of doing business in this country. I therefore, with the greatest respect, urge my colleagues to support these two bills, and I'm happy they have been duly consolidated, and then to make an attempt at the committee level to see what we can add to further strengthen the business utility that is inbuilt in these two bills for the purpose of reinforcing our contribution for the promotion of ease of doing business in the Federal Republic of Nigeria. I thank you very much for giving me the opportunity, Mr. President.
Senator Barrow.
Thank you, Mr. President. My name is Baroji Brain. I represent Kano North. Mr. President, we live in a world that changes everything. So also the economy of every nation changes everything. Therefore, we should not allow our country to have laws that are outdated to be what we use in running our economy. The collective intendments of these two bills, when you look at them, their intendment is to amend our law, KAMA, in the way that it will go in tandem with modernity and also bring accountability and transparency in the way businesses are run in this country. For instance, you have a situation where penalty for infractions in the way things are done in managing companies ranging from 50 naira to 100 naira. This is a very small amount of money. They are not in tandem with what is applicable in the current situation. And the bill is saying change it to something that has value, because 50 naira has little value now. And also, the share capital is being changed from, for instance, private companies from 10,000 to 100,000, and limited liability from 500,000 to 2 million naira. This is fine. It goes a long way to bring our system, monies that could, the share capital to go in line with what we, with the prevailing situation. So I urge my colleagues to support these two bills that are being consolidated together so that we can bring transparency and accountability to how businesses are run in this country, and also bring laws in tandem with modernity. Thank you.
Anybody against this motion? Otherwise, you can allow me to put the question. Okay, Senator Ayoko.
Thank you, Mr. President.
my distinguished colleagues, my name is Senator Atai Aidoko Ali. I represent Kogi East. Mr. President, I am not opposing this bill. I just want to make an observation. Mr. President, if this bill, I'm not opposing it in the sense that the bill can go for a second reading, but in addressing this bill at committee level, the second bill, we should look at conflict between, because the Companies and Allied Matters Act is in the exclusive list. And if you are setting up states, if you're setting up States Corporate Affairs Commission, you mean that means that you are making it on the concurrent list. You are giving the powers of the federal government to the state. So I think we should look at whether we need to amend the Constitution to separate. Sorry? Okay, so I mean, the committee should be very careful in looking at so that there will be no conflict in having a federal corporate affairs and you have a state corporate affairs. That would be, that's the issue, my observations. Thank you, Mr. President.
Distinguished colleagues, after that, I'd like now to put the question, those in favor that this bill, that is the bill, just in favor that the two bills be read the second time, say aye. Those against say nay. The ayes have it. Clerk of Senate.
Mr. President, distinguished senators, the bill for an act to amend the Companies and Allied Matters Act 1990, Cap C20, Laws of the Federation of Nigeria 2004, to provide for the incorporation of companies, registration of business names, together with incorporation of trustees of certain communities, bodies, associations, and incidental matters 2017, second reading.
A bill for an act to amend the Companies and Allied Matters Act 1990 Cap C20 Laws of the Federation of Nigeria 2004 to provide for the incorporation of companies, registration of business names, together with incorporation of trustees of certain communities, bodies, associations, and incidental matters 2017, second reading. This bill is referred to the Committee on Trade and Investment and to back in 4 weeks. Clerk of Senate.
Mr. President, distinguished senators, the bill for an act to amend the Company Allied Matter Act 1990, Cap C20, Laws of the Federation of Nigeria 2004, and for the establishment of state corporate affairs commissions for registration of business names and for other matters connected therewith 2017, second reading.
A bill for an act to amend the Company Allied Matters Act 1990 Cap C20 Laws of the Federation of Nigeria 2004 and for the establishment of state corporate affairs commissions for registration of business names and for other matters connected therewith 2017, second reading. These bills referred also to the Committee of Trade and Investment and two bills to the consolidated as agreed and report back in 4 weeks. I want to congratulate both the Senator Razaki and Omi Agigi for this very important bill that addresses the Company Allied Matters issues. As we all know, part of our effort in improving our economy is improving the ease of doing business in the country. And nothing is so important. In the report of the World Bank found that one of the greatest impediments is the bottlenecks that we see in our company registration. I hope with this bill we'll address that significantly. Leader of the Senate.
Mr. President, distinguished colleagues, I move that because of the committee meetings and other legislative assignments that our distinguished senators are engaged, we step down all other items on the order paper till another legislative day.
Mr. President, my distinguished colleagues, as active minority leader, I move that I second the motion as moved by the leader that all items on the other paper be stood down till another legislative day. I so move.
Distinguished colleagues, those in favor of the motion that all other items on the order paper straight down to another legislative day, say aye. Those against say nay. The ayes have it. Leader of the Senate.
Mr. President, distinguished colleagues, having concluded today's proceedings on the order paper, I move that we adjourn till tomorrow, Thursday, 2nd of March, 2017, at 10 a.m. prompt.
Mr. President, my distinguished colleagues, I rise to second the motion moved by the Senate leader that this Senate do stand adjourned till tomorrow by 10 a.m. I so move.
Distinguished colleagues, before I put the question, just a quick announcement. Bill for Conference, the Bill Corrupt Practices and Other Related Offences Act, Cap C 31 LFN, 2000 Amendment Bill 2016. The bill has passed the Senate passed the above bill with differences. So the conference committee has Senator Utazi as chairman, Senator Mohamed Sabo, Senator Sumono, Senator Issa Misao, Senator Dino Milai, and Senator Matthew Rogidi. The senators should meet with their counterparts in the House of Rep for the conference. Also, another conference, Bill for Conference, Air Force Institute of Technology Establishment, etc., Bill 2016. Again, the Senate has passed the bill with differences, and the committee has Senator Fashe as chairman, Senator Wakil, Senator Nala, Senator Bassi, Senator David Umuru, and Senator Oji. Senators should meet with their counterparts in the House of Representatives for conference. Distinguished colleagues, those in favor that the Senate is hereby adjourned to Thursday, 2nd March, say aye. Those against say nay. The ayes have it. The Senate is accordingly adjourned to Thursday, 2nd March, 2017 at 10 a.m. prompt.